Hello and welcome to the Charles Cook Podcast. The focus of this podcast is state and local issues here in the state of Tennessee. You can follow my podcast on Facebook, YouTube, Rumble, Spotify, iHeartRadio, Google Podcast, TuneIn, and Alexa. Just search for the Charles Cook Podcast. You can also follow me or subscribe on any of those platforms. You'll be notified when I upload new content. The best place to find those links is on my podcast webpage at charlescookpodcast.buzzsprout.com. And you can also contact me by email at charlescookpodcast@gmail.com. Today, my guest is Richard Archie. Richard is from the Tennessee Firearms Association, and we're going to be discussing firearm legislation going on here in Tennessee this session. So with that, Richard, welcome and tell us what's going on here in the state of Tennessee.
Well, thank you, Charles, for having me on today. Right now, what we got going on in the state of Tennessee is infringement at the General Assembly with respect to the Second Amendment. We have a bill up in the House that is House Bill 1005 that has made it through subcommittee and full committee in civil justice and is now sitting in the finance committee. I'm not sure why that is, because as the fiscal note on the bill said it was going to make the state money, I can't imagine they're going to turn that down. But this bill basically does three things, the intent of it anyway. The first is to do away with the criminal aspect of carrying a firearm in Tennessee. TCA Code 3917 1307A1 says it is an offense for anyone to carry a loaded firearm or a club with the intent to go armed. Now, what we've been trying to do for a number of years is to remove that restriction, because I can't understand why we would need to have a crime associated with a right that's enumerated in our Constitution in the state as well as the Constitution of the United States. But irrespective of that, in 1801, the General Assembly passed the first law that made it a crime for you to carry a firearm on your person in Tennessee, and that law is still on the books today. The second thing that this bill is going to do, or would have done if they hadn't killed it in the Senate, was to allow long guns as a permissible type of weapon, lawful for individuals who could possess one to carry. It's very similar to what we passed in 2014 when they said that any person that could legally possess a firearm could keep it loaded in their car, and that's a long gun, a rifle, a shotgun. It didn't make any difference, and I don't think that's caused any problems from that day to this, or if it has, I haven't seen anything in the news, and the departments didn't bring it to bear when they came to lobby against us in the House subcommittees. The third thing that this bill would do is to remove the restriction in Tennessee of the age that one can carry a handgun, or a long gun is the way it would be if they were able to change the second section we were talking about, where they make it a firearms permit instead of a handgun permit. But a number of states have allowed 18-year-olds to carry a handgun or to perfect a permit for that. Tennessee has not up until this year. And Firearms Policy Coalition sued the state. And that's been going on for about 3 years now. They bandied it backwards and forwards, and they've had to say this and they've had to say that, and it's gone back and forth. But when we switched over to the new Attorney General, Jonathan Skrmetti, he said that he wasn't going to try to defend the state against that, especially since the Bruin case had come out in the meantime. We got that decision last June in 2022, and he looked at that decision and what this Firearms Policy Coalition lawsuit was about, and he said that he wasn't going to defend the state against their violation of the Second and 14th Amendment, is the way he put it in the agreed order that he sent back to the court. So this thing that they're doing now would simply follow suit with what the federal courts are going to mandate that we do if we don't do something within the legislature itself. So those three things are what was in the bill 1005: taking away the criminal aspect, to carry a firearm with the intent to go armed, to allow long guns into the permissible class of weapons for lawful people to carry, and to remove the restriction on 18-year-olds to carry a handgun or to perfect a permit for handgun carry. We got that bill passed out of full committee in the House. Like I said, it went over to Finance. They've got to go through that now. But in the Senate last week, the Senate Judiciary Committee amended basically everything in that bill out. And they took out the intent to go armed removal. They took out the long guns into the permitted status and basically made the bill worse than what it was before they started. And that's where we're sitting right now. They have infringed your right in Tennessee as a citizen to carry a long gun or to go forth with your firearm without it being a crime.
Yep. Who was carrying the bill in the Senate?
John Stevens was carrying the bill in the Senate, and John actually has done a pretty good job of understanding what Bruin has said. There are a number of comments that he's made in committee so far saying, guys, y'all need to understand that Bruin has required this to happen, and if you don't, then they're just going to sue us and they're going to win anyway. There was some suggestion that maybe he had worked a deal with the gentleman from Memphis that brought the amendment, but I don't find that to be true at all. I have had a number of conversations with John Stevens over the course of this year as we've gotten ready to look at this bill in the Senate, and I believe wholeheartedly that he's doing his best to get that passed like he had it. He was not happy the other day when they took all of the meat basically out of the bill and destroyed it, just eviscerated it, and he was not happy about it at all.
Probably just hoping that they would say the heck with it and pull the bill.
Well, no, actually, I think what John's wanting to do is to get this passed. I
mean, the one who put the amendment on.
Oh, yeah. Yeah, that's absolutely correct. You know, this whole thing about, and the two senators who were giving us the most trouble on this from the Senate Judiciary Committee are both from Memphis. Brett Taylor, who is the new senator that took Brian Kelsey's spot, and then Paul Rose, who has a certain amount of the district down in Memphis, as well as being up towards Covington. These gentlemen, I've spoken to Paul, and I've sent letters to Brett Taylor explaining to them what the Constitution says and what the SCOTUS rulings are with respect to this. And it's just like they don't care what the Constitution says. They're more concerned about the little old ladies in their church that don't want to see AR-15s paraded around in Walmart. And I've explained to both of them that any person that owns a brick and mortar establishment can put a sign up saying we don't allow long guns in here, and therefore nobody could carry them in there. And it would not, at the same time, relieve them of being able to hold on to their civil immunity, because the way the statutes in Tennessee read right now, if you post against lawful carry inside your establishment, you don't have any civil immunity from a situation arising from a Second Amendment issue. If you do not post, you have civil immunity, which means if you don't post and somebody got accosted in the parking lot from their car to your store, you couldn't turn around and sue the store for lack of looking after you or any hazard that they might have created. But if they do post, then they don't have that protection underneath the TCA code right now. But anybody can elect to post anything that they want to if they own that store. So Walmart could post and say no long guns allowed, just like they post right now and say they don't allow open carry. Right. You have to carry concealed inside those stores, and most stores are like that. But that keeps their civil immunity by allowing some form of Second Amendment carry by the lawful citizen. What they're doing right now is they're saying, you know, we're just afraid people are going to be walking up and down the streets with these AR-15s, and we're just real concerned about that. If you look at Memphis, it's surrounded on two sides by states, Arkansas and Mississippi, that allow constitutional carry of long guns. In fact, I can put a map up, if that's okay, that will show, that shows right now the number of states in the United States that allow long gun carry. There's a code here at the bottom. Red means that it's a crime for you to carry a long gun unless you've got a license from the state. The blue allows you to carry if you've got a permit, and the green says it's just absolutely your right to carry. And as you can tell, we're completely surrounded there by states that allow the carry of long guns without a permit as a right. And Tennessee is, we have companions of New York, New Jersey, and for some reason, which I can't understand, Florida, but we're the only 4 states in the nation that disallow the carry of long guns without it being a crime. And
Yeah, and if you look, even for the more liberal states, Hawaii, California, Minnesota, and was that New Hampshire or Rhode Island?
I actually believe it's Delaware, maybe, and
Yeah,
Hawaii. These states, all of those are very liberal. But the one that I think that most people would be most surprised at is Illinois.
right.
Allows you to carry a long gun without a permit up there. Now they're very concerned about handguns, and the whole point of the Memphis Senators is, well, they've just got such a crime problem down there, and they don't want to see these long guns strolling up and down the streets. But folks, it's a real simple situation. Um, we don't hear anything from Arkansas and Mississippi about people carrying long guns being a problem in those 2 states, because once the novelty of it wears off, it's not going to be a problem. The reason that we're trying to get this corrected in Tennessee, number one, is that it's our heritage as the volunteer state. I mean, in every scuffle for liberty since the inception of this nation, Tennesseans have stood forth as volunteers. I mean, Andrew Jackson called for volunteers to go with him down into Alabama to fight the Red Sticks in 1814. He called for 2,500 volunteers and 5,000 showed up. These people weren't in the standing army. They weren't part of a formal army. They were just folks that didn't want to see their lands and their liberty gone. And so they showed up with their own personal firearms and went down there to fight the Red Sticks, and then turned around and marched all the way to New Orleans to fight the British that were coming up trying to split the United States in 2 at that time. All volunteers, all with their own private weapons. And, at that time, they were happy that Tennesseans had rifles because it was necessary, or we were going to be back under the heel of the British again. Even from the time of the Battle of Kings Mountain, Tennesseans, before we even became a state, loaded up and walked across the Appalachian Mountains to fight the British in I think it was 78, when they had the Battle of Kings Mountain. And George Washington said we wouldn't have had a republic if it hadn't been for those backwoodsmen and the fact that they weren't going to stand still for tyranny. And so from the very earliest point of the republic until this day, Tennesseans have stood in the breach every time there's been a call for liberty and freedom and somebody to have to sign on that 4 line with blood in their personal arms. Tennesseans have been there. And yet what we've got is a group of senators right now, 33 of them, who are telling the 7 million of us in the state that we should not have the opportunity to carry long guns without it being a crime.
Right. So, my question is, and of course, I've been to Nashville several times and seen a lot that goes on down there. So, with the gun lobby, with the lobbying against this, who is the biggest lobbyers against this?
There's no doubt at all that law enforcement across the board is the single biggest advocacy group against your ability and your right to carry a firearm in Tennessee. In the testimony before the House Civil Justice Committee, we had the director of the TBI, David B. Rouse, came in. We had the commissioner of the Department of Safety, Jeff Long, was there. We had his legislative director, Elizabeth Stroker, was there. We had a member from the governor's office that was his liaison, Mr. Easley, came in, and he was the most honest about it. He said the governor just doesn't want us to have this bill. Now, I'm not sure as to the power that the governor should have to be sending paid lobbyists. They're on the taxpayer's dime, and they're coming over there and trying to affect legislation. But the worst of the bunch with respect to just being vociferous against your Second Amendment right was the director of TBI, David Roush. I mean, he said point blank that the Second Amendment did not confer an individual right for people to carry arms. It simply gave the state power to regulate the who, what, when, where, and how people carried. I think he's got bad information. He said he had done a real deep dive into the Bruin case and into Heller that it's built on. He made sure that we understand, or that everybody in the room understood, that it was just about handguns. It didn't have anything to do with long guns. And that's what they're actually really, really, really upset about, with the exception of not doing away with the crime to carry an arm in Tennessee. He said that one of the things that really tickled me in a kind of a strange way was that the Second Amendment, if in fact we had to understand that long guns were covered in it, it was only muskets. And that's the most ludicrous thing that I've ever seen. And if I might, for just a moment, I want to pull up another screen and let the people see what the Heller decision actually says about that.
Yeah. And I actually seen the video where he made those comments.
Yeah, this it may be objectified that if weapons that are most useful in military service, M16 rifles and the like, may be banned, then the Second Amendment right is completely detached from the prefatory clause. But, as we have said, the conception of the militia at the time of the Second Amendment's ratification was the body of all citizens capable of military service who would bring the sorts of lawful weapons they had possessed at home to militia duty. It may well be true today that a militia, to be as effective as the militias in the 18th century, would require sophisticated arms that are highly unusual in society at large. I mean, that doesn't say muskets when it talks about M16s, does it?
No.
So that's what it actually says when we go back and look at what the Second Amendment and then the rulings of the court say about it. It says that it's not just those things which are in fact, let me put another screen up right quick. This is very important. It says here, some have made the argument bordering on the frivolous that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communications and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding.
Right.
You know, that's cut and dried. I'm not the sharpest knife in the drawer, but I can understand that. I got out of the 8th grade and I can read English.
Right.
So,
Well, and the sad thing is many people are turning on Fox News or whatever now. They're seeing everything that's going on with the FBI and stuff on the national level, and they're saying, "Oh, they're corrupt," and they don't realize what's going on in their state. The director of the TBI is the same level as the director of the FBI on the federal level.
that's correct.
And they're not seeing that, and of course you don't get all that on the news here like you do the 24-hour Fox News or Newsmax or whatever. But and these people talking about the AR-15s and the AK-47s, the semi-automatic rifles. Wasn't it just a year and a half ago when we were doing our best from the United States to try to arm the citizens of Ukraine with these type of rifles so they could fight off an invader?
That's absolutely correct. One of the most important portions of the Heller decision is when they talk about Blackstone's commentaries on the Constitution. They quote that in there that says self-defense is the palladium of liberty. what that means is that and each and every one of us have a right to self-defense here. We need to make sure that we understand in Heller, Scalia talks about three things that fall under the auspices of self-defense. One of those can be a criminal, either on the street or trying to break into your house. The second is an invasion, just like Ukraine is fighting off the Russians right now. And I pretend that we've got an invasion coming across our southern border by the day, just tens of thousands of illegals coming in here. And I'm not sure that they have our best interests at heart. And then I saw some mess just the other day that now China and Canada have reached some type of agreement, and then President Biden and Canada have come to an agreement that it's going to be a lot easier for people to come across that border as well. So we're being invaded from two sides. And if anybody doesn't think that's an invasion, they got soft spots in their heads. But the third thing that self-defense is for is against a tyrannical government. And that's what we were involved in 1775 and 1776, is we were fighting a tyrannical government. And so those things are, in fact, gifted to us. And they say in the Heller decision that it's a pre-existing right, that they're God-given. It's not something that the government is responsible for giving to us. The only thing the government can do with the right is take them away from you, because governments don't have rights, only people have rights. And so the self-defense across the board is for those three things: against criminal activity and invasion, and against a tyrannical government. And those are the birthright of every American.
Well, and um, most people don't realize this, but when Jefferson wrote the Declaration of Independence and everybody signed on to it, there was actually four rights that was listed in there. Life, the right to life, liberty, and the pursuit of happiness. The fourth one was listed twice because it was so important. It's the right to alter or abolish your government if it becomes destructive or tyrannical, either which way you want to say it. And when it comes to that point, there's only one way to do it, and that's through taking up arms and defending yourself.
I've heard it put better than I can say it, but there are three boxes that are important in that discussion. You've got the ballot box, the soap box, which you and I are on right now, and the third, if it was required, is the bullet box. So, you can take your choice as to which one of those is going to have to be necessary, but nobody likes to teach in school today that we became a free nation through revolution by throwing off the shackles of a tyrannical government. We didn't negotiate with them. If you read through the Declaration of Independence, it said we've done everything we know to do. We've supplicated, we've written letters, we've sent emissaries, we've gotten on our knees, we've begged, and we've asked, and none of that's helpful. And so now it's just necessary that we dissolve those bonds. And if you're going to require for us to fight to do it, then we, through sacrifice of blood and treasure, will do so. And that's what occurred. That's why we have this shining example of liberty, is we were willing to, again, like I said, on the foreline of that check, write our lives, our fortunes, and our sacred honor. And so that is a birthright that we were given by those individuals who sacrificed them to bring upon this continent that exercise and experiment in liberty.
And that's why it's under assault. And you've heard it said as well as I have: if they'll treat you this bad when you got weapons, what will they do to you when you don't?
Well, it's absolutely right. And if you go back and look at what the founder said, they talk about the fact that unlike most of the nations in Europe who don't trust their citizens with arms, the United States will stay free and have liberty because we have, in fact, a militia that is every able-bodied man, woman, and child, if necessary, can arm themselves and be involved in it. Only 3% of the total population fought the British. Now, you think about that. On the continental United States at that point, only 3% of the total population were actively involved in that conflict. And they were able at that point to fend off the largest, strongest army and navy in the world at that time.
Yep.
And they did it by personal volition and with arms that they owned themselves. And they made sure when They finaled out and were able to sit down and write the Constitution. I mean, a lot of people don't understand that the Constitution was written and they couldn't get enough states to ratify it. And so they had to turn around then and go back and put in the Bill of Rights, which guaranteed a certain number of express privileges and rights and immunities that we have now. One of those rights was the Second Amendment, and it says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And that's what's going on now. Now, our Senate is infringing our Second Amendment rights. You have to understand that there are three real important cases that have come before the Supreme Court. The first in 2008 was the Heller decision, and that talked about they would not allow anybody to have a handgun in their house for self-defense. And David B. Roush, who is our guy, said, yeah, that was only about handguns. It wasn't only about handguns, because the two articles that I read you from Heller talk about long guns are specifically covered at that point. Secondarily to that case in 2008 and 2010, McDonald v. City of Chicago was another group of individuals in Chicago who sued the city because they would not let them have permits to carry outside their homes. Now, Heller said you had to have the right to carry them inside your home or to have them there. McDonald said they wanted to be able to carry them outside on their person. And they found again that it was absolutely your right to do so. And in so doing, they incorporated the Second Amendment against the states through the Due Process Clause of the 14th Amendment. And anybody who has studied any American history at all knows that the 14th Amendment has to do with your civil rights. And so the Supreme Court of the United States said that they were applying against every state the same set of chains that the Bill of Rights put on the federal government to not infringe your ability to keep and bear arms. Now, what we've got in Tennessee right now, they passed the first law that denied your ability to carry a firearm loaded in Tennessee in 1801. That was just 5 years after we became a state in 1796. What the Bruin case specifically says is you can only use historical tradition when it comes to scrutiny on a Second Amendment issue. If you go back and look, in 1796, the analog to the Second Amendment, which is the way they construe this, in other words, the thing that we have in our Constitution that is most similar to the Second Amendment, was Article 11, Section 26. And it said that the free men of this state have the right to keep and to bear arms for their common defense. There wasn't any of that mess over there in the second codicil they put in 1870 that says, however, the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. That was a Jim Crow law that was put into our TCA code and into our Constitution in 1870 at the end of the Civil War, to make sure that the freed slaves could not arm themselves against the Night Riders and the KKK. And it's still on our books today. But in Bruin, they talk specifically about the fact that you cannot use those antebellum rules that were not in force at the time of the founding. And it seems to me that what we've got is a group of senators here who have decided they're not going to read the rulings, they're not going to pay attention to what the Supreme Court has said, and they're going to do it the way they want to. And as a result, they're taking away our God-given rights by infringing on them through legislation.
Yeah. And I want to go back to what they use to help them have cover. And it's, well, law enforcement's against it. Law enforcement's strong against this. I seen a picture that TFA put up the other day on Facebook. Do you have the picture of the committee room with all the state troopers in there?
I don't have that on my machine right here. I don't, but I saw the one you're talking about. You just see it everywhere.
Yeah. I thought that was, of course I've seen it that way, but that's one of the first times I've seen it posted on social media. That the show of force that they like to portray, but I also just like the it's not just the THP, it's the sheriff's associations and the police chiefs
Correct.
group that does all these calling. And, as I had spoke to you about it before, um, I've talked to representatives that says, "Hey, my sheriff is calling me on this gun legislation, or whether it be something besides guns, whether it's a bill on civil asset forfeiture." A lot of people don't understand that law enforcement is actually the biggest lobbyist against these things.
I, I portend and have said this, and it's kind of marked me. There's some people that are very angry at me, but I think that law enforcement is attempting right now to evolve into the fourth branch of government. Article 2, Section 1 of our Tennessee Constitution says that we will have three divisions of government, three branches: legislative, and that's the General Assembly, pass the laws; administrative, and that's the governor's office, and then he gets a chance to either agree to or oppose a bill by signing it or vetoing it. And the third branch is the judiciary. I find nothing in the Constitution that says the TBI, the Department of Safety, the Sheriff's Association, and the Chiefs of Police have any power whatsoever to come in and to testify against a bill in committee. Now, if a legislator wants to ask somebody from the Department of Safety, if we pass this bill, what's it going to cost us for you to enforce it? That's valid. But that's not what they're doing. They're coming over and saying they're philosophically opposed to allowing you to have a right that's codified in our Constitution.
And they're
And
getting paid for it at the same time.
yeah, they're getting paid. They're taxpayer paid lobbyists against your rights. And if you look at TCA code 3916403, it's called official oppression. And it says that any person, any public official that uses his position of power or authority under color of his official employment to deny or attempt to deny an individual the rights and privileges as declared by the Constitution is guilty of official oppression, which is a Class E felony. Now, to me, every time one of these department people come over there and testify and saying we're philosophically opposed to that, they're guilty of official oppression. I've talked to a number of DAs and they say, you can't convict them of that. And I said, well, just go ahead and take Article 1, Section 2 out of our Constitution. And that says that government being instituted for the common benefit, the doctrine against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. Now, if it's important enough to be the second item in our Declaration of Rights, and then they found a place to put it into the code section as a crime, if you try to use your political power and position to deny a constitutional right, I would have thought then that the founders and our framers were pretty sure that was a bad deal. And yet what we've got going right now is they're able to waltz in, do whatever they want to, and nobody calls their hand at it.
Right. Well, they don't want to. Nobody wants to go up against it, because if the facts are, if it's not the growing fourth branch of government, it's one of the largest lobbying organizations in the state. And
That's
you know,
true.
and second to, or maybe one, two, the industry versus law enforcement.
Yeah.
And the one thing that I get that it just makes me chuckle is when I'm driving down the road and somebody's got strong supporter of the Second Amendment on one side of their truck and back to blue on the other side. I understand there's a lot of good patrol officers out there, but they don't realize that the leadership of law enforcement is working to infringe on their Second Amendment right every opportunity they get.
One of the most salient things that I think we can take away from the testimony on the 8th in the Civil Justice Committee was the commissioner of the Department of Safety. Now, the Department of Safety's enforcement wing is the THP, the Tennessee Highway Patrol.
Right.
And to my knowledge, they patrol highways. Is that correct? I think that is so. And so Since 2014, it has been lawful for any person who could possess a long gun to carry it loaded in their car. And so he's up there testifying that it's going to make the lives of his troopers far more dangerous if we pass this bill allowing people to carry long guns, when in 2014 the General Assembly gave us back the right to carry them loaded in our vehicles. And so the only time the THP is confronted with a loaded long arm, because they don't patrol on foot, they just patrol the highways, they're already confronted with loaded long guns. We tried to find out from them how many incidents there had been where that had caused a problem for them, but we've been unable to get any data, because they say, well, we don't keep those records and it would cost a lot of money and we don't have to spend money to satisfy your request. Last time I checked, they worked for us. That's normally not something you tell that officer when he pulls you over for speeding, that you're my employee. What are you doing stopping me? That's not going to work out well. You need to be very polite. And the other thing that I will say, and TFA has this as our mantra across the board, we fully support law enforcement. But these guys are out there doing a job on the beat, and they're different from the people that work at the top.
Mm-hmm.
I can promise you, they all, if you ask any one of the sheriffs, the THP guys out on the field that's actually writing tickets and stuff, the officers in cities that carry a gun, why they carry a gun, if they're honest, they will tell you they carry a gun to get back home to their wife and kids at night.
Right.
They don't carry a gun to protect you because they're not required by any statute to insert themselves between you and a criminal act. Their charge is to maintain general order, to defray riots, and to arrest criminals when somebody else tells them they are. But they owe no statutory duty whatsoever to provide protection or security for any individual. And I can show you a number of Supreme Court cases that say exactly the same thing. Now,
We saw that play out in the high school shooting in Florida,
oh, absolutely.
and where the officer did not go in. And then we also seen it play out in Texas a couple years ago when the school shooting, and they just took their own little sweet time and let it go on for 45 minutes to an hour before they finally went in. And nobody holds them accountable because you can't. There's no law that says it.
That's correct. They actually tried to bring charges against that gentleman down there in Florida, and they weren't able to make it stick because there's no law that he violated by not going to the sound of gunfire. Now, will the average beat cop out there take a bullet for you? I absolutely think they will, but they do that from personal commitment to what they're doing. Police work is simply a job. Nobody goes and makes them go take that uniform, put it on, and go out there every day. It's something that they decided they want to do. They have to apply for the job. They got to go to school. But in the end, the reason that they wear that sidearm every day is so that they get home, not necessarily to protect you. And if you ask them, any one of them, that, they will tell you that's the truth if they're honest.
Yeah.
And I don't blame them. I wouldn't want to go out there and insert myself into fist fights and stolen cars and stuff without being armed either. But they expect us to do that. The average time for a 911 call in Tennessee is a little over 11 minutes. The average time for a heinous crime to take place is under a minute and a half. Yeah. So we're on our own for that 10 minutes, and that's a very dangerous 10 minutes across the board.
Yeah, and I want to bring up something that you said yesterday when I talked to you about, and my son and I seen it on TV last night, the commercial with the TBI director, David Rouse, talking about guns being stolen and stuff from cars. So without stealing the thunder, give us the illustration that you was talking about there yesterday.
All right. So we actually ran a bill this year that has to do with courthouses. From 1796, when we became a state, until 2016, there was never a stricture that said that you couldn't carry your lawfully carried firearm into a courthouse. Now, you could not carry them into a courtroom. That has always been accepted. One of the things they talk about in Heller and then again in Bruin is the sensitive place doctrine, even though we have not had a court case that defines that yet. They just say it's generally accepted that some government buildings, courthouses and polling places and schools, you can't carry weapons into. but it never said anything about the courthouse itself. And so we didn't have a law on the books from 1796 until 2016 that kept you from being able to carry your firearm with you if you go into some of these rural courthouses where you got to go buy your license plate, for example. So we ran a bill that just simply said we would like to revert back to what it was in 2016. It didn't seem to cause a problem then. Don't know why it would now. But the judges and the sheriffs and the chiefs of police just all came unglued about this and started calling the sponsor and just making his life miserable for the simple fact that he wanted to give those rights back to the people. So what it boils down to now is that any building that has judicial proceedings that take place in it, you can't carry a firearm into it. And so what they've done is they've closed down a number of the entrances because you got to have an officer there with a metal detector to check and see. So they've just simply roped off most of the entrances. And like here in Madison County, they got a metal detector up in the middle of the courthouse and you can come into it from two different sides, but they've closed down the other entrances so that you can go down to buy your license plates. Not to go into the courtroom because it's on the third floor and all the places where you do business are either on the first floor or in the basement. But now I can't carry my firearm, so they make me leave it in my car. And if I was a crook and I was going to go try to find a place where it was proficient for me to apply my trade at that point, I'd be hanging around the courthouses because I would suspect that if they're sitting out there watching people get out of the cars, they know they got to leave the firearm in the car, so that would be a happy place for them to try to find something to steal. It's absolutely ludicrous that they're spending my tax dollars to tell me that I shouldn't leave my gun in my cars, and they're spending my tax dollars to tell me that I have to leave my gun in my car.
It's crazy.
It
But
is.
but that's what they do, and you come to expect nothing less from government.
Well, and the problem of it is, it's just like when we were up in the committee the other day. I think there were probably 6, 7 people in that Senate Judiciary Committee hearing that were actually on our side. We had one guy that got to testify, and then you get the Department of Safety and the TBI, they get to testify with just any time they want to. We've got to go up there and we've got to satisfy the committee chair that we have something valid to say. But he will literally say, do we have anybody here from safety? Do we have anybody here from the Sheriff's Association that wants to testify on this? You don't see him asking, do we have anybody here from TFA that would like to come up and give their opinion on what's going on? It just seems like, and we're paying them to be arbiters of our rights, not necessarily to take them away from us. That's not what the General Assembly is there for. And it appears to me that what it boils down to is they want to lessen rights instead of making it easier for us to enjoy them. You look at their oath that the legislators take, and it says that they will vote without favor, affection, partiality, or prejudice, nor will they assent to any act, vote, resolution, or thing whatever which shall appear injurious, I think is the better pronunciation of the word, to the people's ability to enjoy the rights and privileges as declared by the Constitution. If that's so, and we can go back and prove that the Second Amendment has been incorporated against the states, making that second codicil of our Article 1, Section 26 moot, by the way, where they say that the legislatures shall have power by law, they don't. The people have a right that is inherent. It was God-given. It pre-existed the foundation of the United States and of the state of Tennessee. But yet what we have now, even though they've been instructed that they shall not infringe on that right, we've got people that we pay and all kind of other folks on the payroll that are doing their best to make sure that we can enjoy those rights. You show the map a while ago of the different states that allow long gun carry. It's not a problem. If it was, you'd be seeing it on the nightly news every day because we know that the news media is extremely liberal. And so if they don't have those type things to put up to paint us with a bad brush on, they don't exist.
Right. And
And
you don't see any of that showing on TV where people are walking around with AR-15s in Arkansas or Alabama or Georgia or even North Carolina. You don't see that, and so they scare the little old ladies. It's the same way they do with Social Security and Medicaid. that, hey, if you do this is what's going to happen. It's nothing but lies.
One of the most important things that we need to get out into the general public right now is that it is lawful in the state of Tennessee for any person who can possess one to carry an AR-15 pistol. Now, this is the exact same firing control system. It's the same receiver, but instead of it having to have a barrel that's 16 inches or longer, it can have a barrel that's 4 inches long or 2 inches long. And it can have no stock whatsoever. And it can still have the 30 round magazine inside of that handgun at that point, because if it's shorter and it doesn't have a stock, it's no longer a rifle, and it's not a short barrel rifle, it's just a handgun. And so those are lawful to carry. They're concerned, I understand, in Memphis about drive-by shootings down there. I can promise you that it is much easier to use an AR-15 pistol out of the inside of a car than it is to use an AR-15 rifle, which is 3 feet long, where an AR-15 pistol can be 12 inches long.
Right.
And yet those are lawful, they're legal, and we don't see them trying to go back to the federal government and say, hey, we're not going to allow them to carry those AR-15 pistols. And if you ask any sheriff or any deputy out here, they're far more worried about the AR-15 pistols than they are about long guns. And yet, if you see a guy walking down the street with an AR-15, you're instantly going to lock onto him with your eyes and watch what he's doing. If he's got that AR-15 pistol up underneath his coat, you're not going to know he's got it.
Right. Absolutely.
So
Yeah.
it just doesn't make sense to me that they're straining at the gnat and swallowing the camel, as they say.
Mm-hmm. Well, it's not surprising, and you know, as I said, we see it all the time, but I'd seen what the TFA was putting out there in the last couple of weeks, and you know, I told you I was in Nashville a few weeks ago working on some stuff, and but I wanted to interview you guys and talk about this because I don't, as I said, I don't think people realize who the biggest lobbyists are against their gun rights and who's lobbying to infringe on it. And I just think people need to know that, you know, and the news is not going to cover it.
No. And I do want to make this statement that we have some really strong individuals in the House right now. Even the Speaker of the House, Cameron Sexton, has signed on as a prime co-sponsor of House Bill 1005. And Rusty Grills and Chris Todd, who are kind of co-authors of this bill that we're working on right now, and a number of others that have done yeoman's work in trying to get it through the machinations of the sausage making that they call legislation at Nashville. They've done really hard work, and they've done good work, and they've done their research, and they know their stance. So they're not going to try to bring anything to the floor that is not constitutional.
Right.
And when they write a bill like this, they have to send it to the legal department, and the legal department tells them whether it's constitutional or not before they'll let them put it on notice and put it on the floor. And so we all know that what the House asked for is constitutional, and we all know that what the Senate has done is infringe those constitutional rights. And
Well,
that's just obvious.
one of the things that see, and I think you probably know it yourself, is in the last few years, last 6 years, we've turned some people over in the House and primaried them and got rid of some folks out there. And it's high time that we do the same thing with the Senate, because those people are sitting there, and they don't feel any pressure at all. They're going to do what the leadership or the governor wants, and they don't feel no heat really from the people like the members of the House of Representatives do.
Now, House has an election every 2 years, and so they're pretty close to the folks.
Right.
Senate's got a 4-year deal, so they feel like they can operate with impunity because they expect us to forget what they do prior to the next election. I can promise you that I will do everything in my power to remind every person in the districts down there in the Memphis area of what their senators have done this year.
Right.
There's an opportunity, I think, for these bills to go into conference committee and see if they can't work some of this out, because we all know that what the Senate has done is unconstitutional. And if in fact they're able to negotiate with them and come out with a better deal, then there's a possibility still that we could get something decent done this year. But I can promise you, just like this deal with the Firearms Policy Coalition suing the state of Tennessee over 18-year-olds not being able to carry a handgun, even John Stevens said this about a month ago when we were talking about this bill, getting ready for it to come up. They didn't let him put it on notice. They made him roll it. But he said, guys, y'all have got to understand, you can either take care of this legislatively or they're going to sue us and they're going to win, because the wind's in our sails, not in theirs right now. Bruin has told us that the only thing you can use for scrutiny when it comes to the Second or the 14th Amendment is historical tradition. There is no historical tradition denying the citizens of Tennessee an ability to carry a long gun in case of confrontation.
Mm-hmm. Yep.
And we got to keep that on front burner. We can't let it sit on the back and simmer. We need to bring it up front and keep pouring water in it so that pot boils and people have it fresh on their mind. I intend to do everything that I can to achieve that.
And one thing that I would do that I want to remind people is when you want to study things from our founding history, our founding era, go back and study, get you a dictionary from that time. Go get you a Nola Webster dictionary, and you can buy it. It's about that thick, it's green, or you can actually download the app and just go back and look and see what arms meant back in 1828, when around at the time that all this stuff was being put into our founding documents and stuff, and see what it meant. You know, as I said before, it meant mortars, cannons, whatever. It was arms. It was the same thing that the government was allowed to have, the citizens were allowed to have.
That's correct.
Or to be able to provide a militia.
That's correct. Scalia defined arms in the Heller lawsuit. He said it's anything that a man can pick up in his hand and use to strike at for defense or offense against another. Now you think about that, and when he was talking about all forms of bearable arms, you know, we may not think that it is prudent for somebody to buy a tank because you can't pick them up and carry them. But if you read Scalia's words, what he said was that all bearable arms are covered under the Second Amendment. We've got to get our legislature to understand that. And you look back at that map and see all that green as opposed to that little red spot right in the middle of the country being Tennessee. That's embarrassing to somebody that's got volunteer as their nickname for a state.
Yeah, yeah,
It
exactly.
really is.
Yeah. Okay. Well, anyway, we're going close to an hour here, at least 50 minutes. So, anyway, so we'll wrap this up. Anything else you want to add to this?
Well, anybody that's wanting to follow along with TFA can find us at our website, and that's www.tennessee spelled out firearmsplural.com. We have all the constitutions. We have a lot of research there. We also put out a weekly notification on legislation and tell you what's happening with the bills. And anybody that goes to that website, whether they sign up and join as a TFA member or not, can have access to those weekly updates. You can just sign on and you can get it emailed right to you, and it doesn't cost you a dime. But what it will do, it will keep you informed as to what's going on. And their best defense right now is an uninformed public. And what we're trying to do is to spread the word as much as we can. So those individuals that want to go read about it and see about it and know what's going on with respect to Second Amendment in Tennessee, www.tennesseefirearms.com is the place to go.
And one thing that I do want to add to what you just said, you guys are not like the NRA. You don't have guys walking around in big fancy suits and living in big fancy homes, drawing a salary from the association, correct?
That is correct. None of the board of directors or any of the directors take one dime from the dues or from the money that we generate in our annual event. When I drive to Nashville, I pay for my own gas and I buy my own meals. I pay for Uber myself to get in and out. I don't take any salary whatsoever, nor do I get repaid for any of the costs that I incur, nor does John Harris, who probably donates $100,000, $200,000 worth of billable hours as an attorney every year working on this stuff. We don't make any money off of it. It's a labor of love for us. We're just trying simply to set our children and grandchildren up as well as we can before we're no longer here. And so we're not like the NRA. We don't make $400,000 a year to keep our suits up. I've got the same old threadbare sport coat that I wear every time and a couple of wore out ties, but I show up.
Right. Okay. All right. Well, thank you, Richard, for joining me today and giving everybody a wealth of information. You guys are your single issue group, and that's what you focus on, and you guys are very good at it, and we appreciate it. Thank you for what y'all do for gun rights in Tennessee. And we appreciate that. And I'm glad to have you on, and hopefully we can have you guys on again, kind of put more information out there. So with that, and please stay on the line when we finish here, Richard. With that, I say good day. God bless you all, and thank you. And we'll catch you again in the next podcast.